Hi, everybody. Welcome to the Art of Estate Planning Facebook Live. It is the 14th of April. I am Tara Lucke, and today I am going live with a special training all about succession planning for family trusts. So while we just wait for a few people to jump on in, I would like to take this moment to acknowledge that today I'm hosting the training from the lands of the Yugambeh people on the Gold Coast. I want to acknowledge the traditional custodians of the lands on which each of you are also living, learning, and working from today, and pay my respects to elders past, present, and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia. I'm going to just check that the broadcast is working. If you want to let me know if there's any tech issues or anything like that, pop that in, but it looks like it's all good. So I'm going to get started. I'm so excited for this topic. It is one of my favorite topics. Before I dive into it, I've got a few sort of disclaimers, typical lawyer, right? Bit of context. This is a light version of a very detailed training that I have prepared for lawyers who are in the TT Precedents Club and also who buy my Trust Succession Precedent Pack. So I know our audience here is a mix of lawyers, accountants, and financial advisors. So I'm going to make it more geared towards the financial advisors and accountants, just so that you have an understanding of the key principles, but on the assumption that you will not be preparing any of the documents yourself. If you are a lawyer who is going to be preparing the documents, I suggest you go and get access to the 90-minute really detailed training. We dive into a lot of the principles from the cases. We've only got an hour here, so I want to keep it kind of high level and more geared towards the non-lawyers. I will also say I've done that because if you're not a lawyer, you should not be preparing any trust succession documents. That really is legal advice. It's not covered by your insurance, and we'll touch on it a little bit. It's really easy to stuff this up. I see a lot of lawyers getting it wrong. At least they're covered with insurance. So this is really designed as a financial advisor or accountant or a lawyer who's not a succession lawyer, just to inform you of the principles in this space so that you have a high level understanding when looking at this for your clients and working with other professionals. Okay, the other things I'll just mention is I'm not talking about any stamp duty requirements here for trust documents. That's a whole detailed topic on its own. I will mention some cases. If you're interested, especially if you're a lawyer, go off and read them. They're really enlightening and it will serve you very well if you get involved in advising on this space. I'm not going to talk about things like amending beneficiaries, resettlement, CGT event E1, anything like that. I'm also not talking about changes of trustee. And I'll just mention, so if you are a lawyer getting involved in this space and you want a peer review, you can always do a one-on-one coaching session with me. Okay. So that's the disclaimer. If you've got questions, I really invite them. I can see the questions up on the panel. If you don't approve the StreamYard program, I may not be able to see your name unless I look at it on my phone, but we'll work that out as we go. So please do ask the questions. Also, I will be putting the replay of this training in the group under the guides tab. So that's where all of our training replays live. So if you have to run off, don't stress. You can always come back and watch this, or you can watch it again as a resource. And lastly, a huge welcome to some of our new members. We have had a huge influx of members. Big shout out to Chris from the Accountants Facebook group for giving the Art of Estate Planning Facebook group a promo. So a very warm welcome. I hope you enjoy the training. If you missed it at the beginning, I'm Tara Lucke. I'm the host of this group, and it would just be me today talking to you about succession planning for discretionary trusts. Okay, so I really love this topic because, as if you're familiar with family trusts, you will know, just like our clients, just like each of us, no family trust is the same. We really can't assume that they're all the same. They're so different. And that's what makes this a really interesting and varied topic. Yes, it definitely keeps us on our toes, but it really, when you dive into the trust documents, it really does make it interesting because it's different every time. But that's also a huge, buyer beware sticker, because you can't be on autopilot when you're working in this space. You can't make assumptions. You really do have to dive into the detail. The other reason that I am really excited to deliver this training is because adding on trust succession is a huge value add to your client value proposition. And for any client who has assets in a family trust structure, it is a really critical component to add to the core estate planning documents like your wills and powers of attorney. So you really shouldn't be ignoring this or carving it out of your advice. A lot of people with trusts have significant value in there, and sometimes the trust succession piece can be more important than the wills and powers of attorney. Let's begin with some core principles. So, as I said, this is a bit of a this is a more advanced topic. So there's even more advanced level if you want to go and explore the 90-minute training of this in the TT Precedents Club for lawyers, or if you buy my trust succession pack. But if you're on the other spectrum and you're fairly new to discretionary trust, I'm not going to be diving into what is a trust, how does it work. I'm going to have some assumed knowledge that you understand the fundamentals. So if you are trying to brush up on the fundamentals of trust, go to the learning guides module. There's some presentations about trust there. And of course, I also dive into that in my Art of Estate Planning course. So I'm going to assume that you have a pretty good working knowledge of the fundamental legal features of a discretionary trust. The core principles of discretionary trust succession. Firstly, number one, any assets that are in a discretionary or family trust are not assets that are capable of being disposed of by a will. So your clients might come to you and say, "Oh, I want to gift this asset under my will." They may not even appreciate that they don't own it. It's owned by the trust. But even if they do appreciate that it's in the trust, they may not understand that it's not something capable of being gifted by their will. So we cannot gift an asset in a trust through a beneficiary or a controller's will. The asset remains in the trust. The trust does not care if that person dies. What needs to happen is that the control of that trust needs to be transferred. So the trust keeps on keeping on. And if a controller dies, then we need to nominate who is going to take on the control instead. So we need to hand that over. The other thing is that all control roles need to be considered and addressed in the succession plan or estate plan. So I'm going to talk a little bit about how we can do that. There's a few options, but beware that when we're talking about control roles, there's quite an array of them, and you really need to read the deed from front to back, because sometimes a control role may not be obvious. It might not be in the schedule. It might just be sitting there in a clause. It might just be granted to a person, but not named or described with a name that we're used to seeing. It might just say, while this person is alive, they have these powers. So let's keep going. And thank you. I can't see whose comment that is, but I have a feeling it's Carol Grimshaw. And yeah, please feel free to promote the town hall celebrating the anniversary of electronic wills witnessing in Victoria. So when I say controller, I'm kind of referring to like a fiduciary role. So I like to refer to the word controller because there's a bit of debate about whether, some of these roles are fiduciaries. So when I say controller, I'm talking about the trustee of the trust, anyone who could be an appointer, a principal, a guardian, or as I said, they may not even be defined, but they might be a person who has special powers under the trust deed. So let's have a look at some of the options available for succession planning of a control role. And we'll keep it really simple with our trustee. So here's our family trust. And just by the way, if you're not, if you're going, why is Tara switching between using discretionary trust and family trust? I'm going to just when I say family trust, that's not a defined legal term. That's just a colloquial phrase that really refers to a discretionary trust where the beneficiaries have discretionary entitlements. So I'm probably going to switch between them two, but they kind of mean the same in this context of the training. So in Queensland, at least, this will vary. I know we have people around the country. I've just focused on Queensland for today. If a trustee dies and there is no successor mechanism in the trust deed or no one nominated, the role of the successor trustee actually falls to the public trustee. And then it's up to the public trustee to then either hand that on or decide if they will continue. So for a lot of people, that's the base point. And I would suspect that most of your clients would not be cool with that. Another option is that you can rely on any default successor mechanism that's already within the trust deed. So sometimes it will say, if the trustee dies, their executor or their legal personal representative will automatically take on the role. So that's what I mean by a default successor mechanism. Another option is you can take a bit more control and try to nominate a successor in the controller's will, or in a specific deed of successor. And then lastly, you can vary the trust deed and appoint a successor or insert an appropriate default successor. So these are all the options kind of available to a client. I'm going to go through the pros and cons of these bottom four in a moment, but I just wanted to lay it out flat that if your client comes to you and they have this structure where there's an individual trustee only, these are the options usually available to them. Now, it gets even more complicated if there also happens to be another control role, like an appointer, principal, guardian, that kind of thing. So just to highlight the distinction between the two. So the trustee is the legal controller of the assets, right? Any assets will be registered and recorded in their name. They are responsible for running the trust and managing the trust for the benefit of the beneficiaries. And they can also choose which of the beneficiaries can receive income and capital distributions from the trust. Typically, but not always, the job of appointer, principal, guardian is to perhaps oversee the role of trustee. So they may need to consent to the exercise of certain powers by the trustee. And often the appointer or principal will be able to unilaterally change the trustee. So boot out the trustee and put someone else in. So in a lot of trust deeds, that this appointer or principal guardian role, the pink on the diagram, is like the god of the trust, the ultimate higher being. So it gets confusing, as you can see, where we've actually got two layers of control operating at once. You can't just sort out the trustee and not worry about the appointer. So the appointer principal guardian is not typically addressed in a trust act or a trustee act, although that's my understanding in Queensland. Please let me know if that is different in your home state. So then we have the question, if there's no plan whatsoever, what happens? Do the powers just lapse? What does that mean? Do powers that trustee once had are no longer available, or is the trustee completely unfettered? And then we've got those same four options that I mentioned for the trustee role that can also apply for the appointer role. So you really need to be quite diligent when plotting out the succession plan for a trust where you've got multiple controllers to make sure that they all align. Okay, that's cool. What happens when we've got a company involved as a corporate trustee? Because the benefit, obviously, of having a corporate trustee, as I'm sure you're aware, is that it endures. So same as the trust, the The trustee will not be removed if a shareholder or a director of the corporate trustee passes away or loses capacity. That entity remains, it endures, but we need to deal with the shareholding and the directorship. So you have options such as the shareholder can gift their shares in the corporate trustee under their will. Whoever is the legal personal representative of the shareholder or the new shareholders can resolve to change the directors. You could have a constitution for that trustee that specifies new directors or places limits on who the shareholders can be. And then in the event of incapacity, we've got power of attorney options as well. So can you see suddenly that our possible recommendations to a client when crafting our trust succession strategy is quite broad depending on the unique situation of the trust structure? Things get even a bit more complicated when we throw in a corporate trustee and mix that with an individual appointer principal guardian. So I've just copied over the options in pink here that we talked about for the individual trustee and individual appointer. They're the same as I just mentioned, but suddenly we've got 1, 2, 3, 4, I think that's like 8 to 10 options available that as professional advisors, we need to guide the client on to choose what is going to be appropriate to achieve their objectives, what's possible under the trust deed, and understanding the impact on the family dynamic and the controller's objectives. So aligning the succession of the family trust with the estate planning objectives is really critical. As advisors, it's very important to get clear instructions from your controller. And in this case, I'm assuming your controller is the testator. Or, that we're talking about the person who, and I guess I'm looking at this through the lens of a lawyer preparing a will. But perhaps if you're a professional advisor like an accountant or a financial advisor, then it's your client and you're looking at their will and then what's happening with the assets. So in this narrow presentation, I'm really looking at, we've got a testator and they hold a key control role as a trustee, an appointer principal guardian, or maybe they're a director or shareholder of a corporate trustee. So getting instructions from them about who's intended to control the assets in the trust and who's intended to benefit from the assets in the trust is really key. And if you've seen any of my training before about discretionary trusts, you would know that the separation of control and the right to benefit is one of the most key features of a discretionary trust. Now, sometimes control and benefit go together, but sometimes you want particular people to control and other people to benefit, or maybe 1 or 2 people to control and a range of people to benefit. A beautiful example to demonstrate this is even where you might have minor children. They're not 18, they can't be the controllers, but they are intended to benefit from the income and capital of that trust. So we have to appoint people who are trusted to be the controllers, even if it's just for a short time. So getting instructions on this from your client really is the starting point. Then understanding what is their objective. And the nice thing about trusts, and this is the same for testamentary trusts, right, is that there is scope for the controller to rule from the grave. So I like to get instructions from the client about what do they want to do here. Are they happy to just facilitate an initial transfer of control under their succession plan, and then whoever they've nominated as the successor controllers are then empowered to keep planning on the succession for their roles and so on. So really what we're doing is just one layer, we're handing it on. It's all yours. I trust you to make the right decisions about this trust. I trust you to prepare your own succession plan once you take on this role, and it's yours, and hand it over. Or does your controller actually want to hardwire in long-term succession planning over multiple eventualities and rule from the grave? Because your options here might vary based on the information and instructions that you get from your client on that. And I shall just say, if you do have any questions or you want more specific examples about any of these points that I'm making, throw it up in the chat. I'm happy to get questions. This is designed to be practical, so feel free to ask the questions. The other thing is that it's really important to align what you're doing on the family trust with any testamentary trust. So, sorry, TT means testamentary trust if you're new here. And then also what's going on with our executors and our financial attorneys. So we've got a variety of control roles going on across an estate plan. Let's make sure that what we're doing from a control perspective works with the will. So I had a one-on-one coaching session with a lawyer a couple of weeks ago, and she was updating an estate plan for a couple who had a lot of wealth in trusts, and her instructions were like, no, we've already dealt with what's going on in the family trust, but we've got deeds to deal with those. So carve that out of your advice and just do the wills. And, one of the things we spoke about in the coaching call is how's she going to navigate that? Because we got to make sure that the control for those trusts that was put in and not informed by the strategies developed for the testamentary trusts all lines up. So it is really hard to take a siloed approach, and hopefully maybe it works out. But, as part of a comprehensive estate plan, a lot of energy is put into getting the right control structure to protect every beneficiary's interests, to make sure there's accountability and check and balances, and that the right people are taking on the roles. So all of that work really should translate over to what's happening in the family trusts as well. So I've got some diagrams to show you maybe just two very common scenarios. Obviously, as I said at the beginning with the hand pictures, these are as varied as they come. It really depends on every particular client's objectives, their family dynamic, but often these are two main scenarios I see. So often it will be that they want the same people to run the family trust as the testamentary trust and the executors and everything like that. So often modern trustees will nominate the legal personal representative, so that means the executors or the financial attorneys typically, as the successor. So that is like the default plan. And if you have the same intended controllers across everything, then usually that's a really good strategy and it works. But if the family trust is earmarked for a particular beneficiary, so where you've got like an adult child who is going to inherit a business, they're already running that business, and under the estate plan, it's going to become theirs, or farming families, then often you'll find that different trusts are earmarked for different beneficiaries. And in that case, having the executors as the default default controller is not going to work. You really need to make sure that that earmarked beneficiary or a representative of theirs takes control. I can just see a question. Yes, it is being recorded and it will be available under the guides tab after the replay. So don't worry if you can't get it. Another thing to remember is don't forget about loan accounts and unpaid present entitlements. So the accountants will be all over this, but you have to be really wary of leakage, particularly, where we've got a trust earmarked for one person, but then a UPE or a loan account is owing to a testamentary trust under the estate. It can divert those funds out of the trust that was intended for that beneficiary. Letters of wishes. So these are morally binding documents that accompany the will. These can be helpful. They're not enforceable at law, but they can be helpful in some instances to explain what the intention is. So to show you in diagram form, if you're intending that the same people take over everything, so on the left in blue is what happens now while our controller is still alive. If they pass away, on the right in pink is our succession plan. So they're setting up a testamentary trust, and then they've got their family trust. So that testamentary trust obviously becomes enlivened, and they're saying, well, I've chosen my panel of controllers. So our people in pink, and they're going to control the testamentary trust as trustees and appointor. And under our succession plan, we make sure that they also control the family trust as trustees and appointors. So the same people across everything. They probably don't particularly care from their perspective which trust they're acting for or which hat they're wearing. They've got control and decision-making capacity across everything. Nice and clean, very beautiful structure, easy peasy, right? And in this case, defaulting to the legal personal representative is a really nice solution. I call that proactively choosing to do nothing if you've got a modern trustee that does that. Same scenario, but we've got a corporate trustee in the mix. So often, and this kind of depends, but you might often find that if this is our will maker who is the appointer, so I'll just move that away, the appointer and the shareholder. So if she passes away, she might leave her shares to the testamentary trust. So we've got our testamentary trust sitting on top of our family trust, and she has nominated our people in pink to be the control roles everywhere. So they're the trustees and appointers of the testamentary trust. As the shareholder of the corporate trustee, they can resolve, and they would be the executors too, right? So they can then resolve who the new directors of the corporate trustee are, and also take on succession of the role through appointor. So beautiful, nice, pink everywhere. I love it. But as you can see, there's 4 different roles here. So as professionals, we need to make sure that we are dotting our I's, crossing our T's, and getting all of this in alignment. What about where we've got the trust earmarked for someone? So in this case, we actually want the family trust to go to Mr. Green. So our pink people are going to take on what's in the testamentary trust, so the personal assets that flow into the testamentary trust, but the family trust is intended for green. So in this case, you would have them separate, and we need to make sure that green takes over those control roles. So you would probably be looking at nominating them specifically. Oh, sorry, going back the wrong way. And then corporate trustee, again, you've just got to make sure in this case, that should be a corporate trustee there, and they own the shares, that the shares are gifted to Mr. Green under the will in the corporate trustee, and perhaps making sure that the executors will appoint the right director, or embedding that in the constitution if you're really worried that the executors won't follow that direction. And then our standard plan for the testamentary trust. So that's like a really simple scenario. It gets complicated when you have multiple beneficiaries sharing a trust and multiple testamentary trusts under the will, so multiple adult children, because as you know, assets owned individually can be divided into portions, right? So any individual assets can be split thirds into a testamentary trust, one for each child. But the assets in the family trust stay in the family trust. And so what we have to look at is shared control. So even though your client might have said, well, I really think I want to give each of my children autonomy over their inheritance, they should just get their own trust each. And I'm not going to talk about family law consequences. There's other presentations on that. So, there's a lot to think about here. If we just look at it through the lens of family trust succession, you can't give the children autonomy over a third of the family trust for those assets in the trust. It's a shared asset. They stay in there. So we need to look at how are they going to manage this as a joint control situation. And it gets messy because depending on whether you're controller is a company or an individual, we have different decision-making rules. So, for instance, if we look at the right-hand column about individuals, the rules about the trust are going to be, have an overriding governing structure of obviously the trust deed, but also the Trusts or Trustee Act from that state. And typically, decision making by individual controllers is joint, or i.e. unanimous. Joint means unanimous. So all three of them, 100%, have to agree. And so that means, for instance, if one of them doesn't agree, and let's use the example of it's 30 June, they've got to make their income distributions. If one of them doesn't agree, well, they can actually have a veto power and no decision is passed. So if two of the three children collude with each other and try to outvote the other, then the decision just doesn't get made, right? Versus, sorry, I've lost my little second screen. I trust that we're all working fine. But what that means is I've lost my questions. So I'll just bring them up here for you. Yeah, beautiful. So that means everything's unanimous. They're protected. They have a veto power. It also means you could get stuck in a deadlock or a stalemate situation, which is not ideal, right? If we look at what happens when we've got a corporate trustee, well, we're in the realms of the Corporations Act. So we've got decisions are mostly made by simple majority. So two of the three, or potentially a special majority, but like decisions about distributing income and capital is just a simple majority. So two of the three can resolve to collude, outvote that third child. That third child may never ever get a distribution from that trust. So suddenly that can really undermine the protection advantages of the trust and the objectives of the testator. I'm just going to try and fix this up because here we go. Beautiful. I think that's still broadcasting. Yeah, thanks for bearing with me. I've got a USB plug-in cable that is playing up a little bit. Beautiful. Okay, so you have to be really careful here about looking at the objectives and your structure. So I've summarized here on the slide. 3 kids take it over. If pink and green want to leave blue out and they've got a corporate trustee, they can. Yes, we've got appointors which have to act unanimously here. And so can the appointors do something if blue is unhappy, if she's being outvoted at the director level to resolve to distribute? What can she do? What can the shareholders do? Well, the shareholders can resolve to change the directors, but that is she can't do that on her own. What can the board of directors do? She can't do anything. She'll just get voted down on every resolution. As appointors, yes, appointors can change the trustee, but they have to act unanimously. So if blue puts a proposal to the appointors to change the trustee and sack trustee co, she needs pink and green to vote with her, which they probably won't do because the arrangement works in their advantage. Even if blue was the sole appointor, her power is retrospective, right? All she can do is sack the trustee. Maybe she can try and bring a claim as a disgruntled beneficiary that the trustees are not making their distributions appropriately and not exercising reasonable care while acting in their duties. And there's been a few cases like the Re-Oes one and Marcella that are starting to give greater power to beneficiaries on that, and we'll have some training coming up on those. But really, she's in between a rock and a hard place. So we have to be looking at this and preempting this and getting the structure right. And so you can do things like a hardwired constitution or getting your appointors appropriate to try to avoid this situation happening. So let's have a look at some of the methods of succession of individual controllers. So we've talked about this before. Number 1, rely on the default successor mechanism in the trust deed. 2, nominate a successor in a will. 3, do a separate deed of successor. And 4, a deed of variation. So let's have a look at number 1. I've got a sort of layout here. Use it when these things align and the pros and cons. So you can rely on this, and it can be a good option where your trust deed has an appropriate default successor for both death and incapacity. So a lot of modern trust deeds, if you've got a trust deed set up this year or last year, it probably will deal with this and you get a tick. If you have one that was set up 10 years ago, I don't know why, but a lot of them brought in the concept of a default successor for death, but they kind of just overlooked what happens on incapacity. So check that incapacity too, because if your controller loses capacity, that's a big problem. So we need to deal with both. And then secondly, obviously this is only appropriate if the default successor is the right person. So if it nominates for instance, the legal personal representative. So as I said, where you've got all the financial controllers managing all the trusts, the testamentary trust, family trusts, that's probably fine. If you've got the trust earmarked for a particular beneficiary, this is probably not fine. So it's simple, it's affordable. Often you don't have to do anything. The plan is already there, but it only works if you've got an appropriate successor. It's appointed for all disqualification events. And one thing I'll just mention is it's only nominating a successor for like one point in time. So if your client or controller wants to rule from the grave, that's not probably going to happen here. So for instance, if A wants to nominate B as their successor, and then under their estate plan, they've then got C as the backup if B can't do it. If A dies and then B takes over, but then 6 months later, B dies, it's going to go to X, probably B's spouse, as their legal personal representative, not to C. So A is really relying on B to look at the broader objectives for the succession of this trust and say, yeah, who's meant to take over? Is this meant to stay in the bloodline? If B is like child 1 and C is child 2, is B's spouse really meant to be running this trust, or should it have gone to C? And then we're relying on B to then look at nominating their own succession plan. So this is a short-term fix. And as I said at the beginning, this is something you need to get instructions from. Maybe that's totally fine with your testator and they're just a trust B. B can be empowered to then plan out the succession for the trust appropriately based on the circumstances at the time. But if they want to hardwire it in, it may not work. I've got here an example from a deed of what this might look like where it doesn't deal with incapacity. So this kind of looks cool on its face, right? Like the appointor, and on their death, the last surviving appointor, such person nominated to be the legal personal representative, blah, blah, blah. But it only deals with death. Doesn't mention incapacity anywhere here. I know you can't read this because it's a bit, I'm not sitting there giving you enough time, but you have to really be careful and really read it carefully. So let's move on to nominating a successor in the will. So a lot of people suggest this. So you need to be able to firstly have a power in the trust deed that allows that controller to nominate a successor by deed or will. Anything you do with a trust needs to have a specific authorization in the will allowing it to happen. So you can't just go off and I'm the appointer, I should have this power, I'm just going to do it. You need to point to the exact clause allowing it. And as a lawyer, that thread, that point weaves through every single thing that you will do relating to succession of a trust. You need an express power. So Use that when you have an express power. Might as well use it when the default successor is not appropriate, or else that's easier to rely on. And only if the controller does not want to nominate a successor for events other than death. So nominating a successor in the current controller's will is nice and simple. Usually you're already preparing the will, or if you're the lawyer, you're preparing the will, so it's not like costing you extra to go and do a different document. But I personally do not like this approach. I don't think it's comprehensive enough. For several reasons. One, if the succession is nominated in the will, I think there's a real argument that it is only enlivened on death. It doesn't deal with other events like incapacity or bankruptcy. Secondly, I just don't like it from a privacy and trust succession perspective, because I think putting the succession plan in the will makes the will a trust instrument, or at least that clause of the will. So when anyone requires disclosure of the trust deed, do you have to disclose the will? I don't think a lot of testators would want that. And I think what happens is obviously no one remembers or thinks about that. So the succession gets overlooked, right? You don't want to disclose the will to the bank, to the titles office, under a contract, anything like that. So you don't, but then professional advisors who are working on this may not realize that there is a succession plan in place until someone dies. So I just don't like it. I think if you need to rely on something or take action above the default plan, then I prefer to do a specific deed of successor. So this is like a separate standalone short document nominating the successor instead. So obviously you need a power in the trust deed allowing this. The advantages are that firstly, you can control for multiple eventualities. You've got the sophistication or the ability to be sophisticated about your planning. So, you know how I said before, we've got A, and then they want B, and then C, not B's spouse. Well, you can do that in this deed. You can say, yep, B first. If B dies, well, it's not their legal personal representative. It is then C, or maybe it's C and D together at that point. And you can sort of keep ruling from the grave a bit more. It's a separate standalone document, got nothing to do with the will. So it allows you to disclose all the trust terms without jeopardizing the privacy of the will. And it also allows you to nominate a successor for multiple eventualities, incapacity, even relationship breakdown, bankruptcy, that kind of thing. The disadvantage is it does require preparation of an additional document, and you can't do it if you don't have a power in the deed allowing it. The last one is a deed of variation. So that's changing the original constituent trust deed. So you would do this when you don't have appropriate powers in the deed to let you do whichever option you wanted, right? So you have to update the deed first. So your deed is old, out of date. Often you might see this done in conjunction with one of the others. So you fix up the deed either to put in a good default successor mechanism, and then you're happy to rely on that one that you've just added in, or you fix up the deed to allow a deed of successor to be prepared, and then you go off and prepare your deed of successor. Sometimes you just do the deed of variation and you just like hardwire in the plan in the trust deed itself. What it does, the advantages is it presents an opportunity to modernize the succession mechanisms in the deed. So this makes it easier for future controllers to nominate a successor. You can be more consistent about your successor mechanisms for trustees and appointors and principals, because often they will be different in older deeds. You can tidy up any ambiguity. You can expand so that all disqualification events are covered, or insert your appropriate default successor mechanisms as well. But again, it does require an extra document, more costs, and it is more complicated because you have to align it with the original deed, and it just creates the opportunity to make more errors. So you really have to be on the ball, not on autopilot. And of course, it's only available if your variation power is sufficiently broad enough. And I will talk about that very shortly. So tips and tricks. And again, I'll just reiterate, financial advisors and accountants, I don't want you preparing any of these. They're legal documents. You're not insured to do them, but you can take on board these tips to check any documents that happen to come across your desk, make inquiries of the lawyers who prepared them, and just, keep an eye out for your clients. So when I say tips, this is probably more like what not to do. It's a list of things not to stuff up, okay? You must have an express power in the trustee to support anything that you want to do, right? Like any action you want to take, you have to have an express clause to rely on and you have to comply exactly, okay? Secondly, if you're nominating a successor, make sure no one is prevented from holding the office. Like you can't nominate the settlor to be the successor, typically, for instance. That will be prohibited. Sometimes there's notional settlor clauses. So they're saying, well, if anyone's contributed money into the trust, they will be treated as a settlor and they're not allowed to take on a control role. Getting consent. A lot of the cases coming through where people are challenging succession planning for trusts or changes of controllers is because the right people did not consent. Any notice or consent requirements need to be strictly complied with. If you're in the TT Precedents Club, you will know that I'm banging on about this all the time. Be extremely wary of varying schedules. I've got 3 cases for you to read where the schedules were varied and the variation power did not permit it, and it was a waste of time and a big scope for challenge. Don't go beyond the scope of your variation power. Take interpreting this variation power extremely seriously. I'll talk to you a little bit about mere powers and trust powers. Don't go beyond the scope of the power to nominate a successor. You have to do exactly what the power in the deed lets you or update it. Make sure if there's previous succession plans, you expressly revoke that plan. Check if there's any minimum maximum levels. Be aware of like quasi control roles. The original primary beneficiary has power to or must consent to the exercise of these powers. And if they die, then the trustee can't do them. And it doesn't ever say there's an appointer, but there basically is, and you have to sort that out. Often that type of thing will end on a controller's death or a specific person's death. And if that's the case, then you have to make a plan to sort that out if you can within the scope of your deed. New cases like McCanty and re-OEs are really focusing on your hygiene around these documents. So make sure that you have your minutes and your resolutions documenting who's consented, who's been received or who's received notice, all of that. It's really important. Don't cut any corners. I mentioned UPEs and loan accounts at the beginning. And if you're dealing with a corporate controller, check the constitution as well. Make sure there's no specific rules or, another layer of rules that you need to navigate. So really quickly, relevant cases, we're going to finish in about less than 10 minutes. So I'm not going to read all of these, but if you remember anything from this presentation, the exact terms of your trust deed really matter. You have to read the entire document, print it out, read it from front to back and then back to front. Read every single page. Don't just go to the clause or the page with the clause that you're relying on, because yes, you would hope with a modern trust deed that it's sensible, but these old trust deeds, especially the ones like on typewriters, there's no logic to them, honestly. Like things are all over the shop. Things are in definitions, things are in schedules, things are in other clauses. You have to read it really carefully. If you buy my estate planning precedents, the top works package includes a discretionary trust checklist that can help you stay on track and point to what you need to look at for these things. But my main message is you can't be on autopilot. If you're tired, if you haven't had a good sleep, it's not the time to be doing this work. It's so easy to get it wrong. Jenkins and Ellett. This is an easy case to read. It's not that long. It's a really good one. Basically, the variation power did not permit the purported variations to the trust deed. So they wanted to change the appointer by varying the schedule. But for several reasons, this did not work. Firstly, the nature of the variation power said only trust powers could be varied. But the deed of variation tried to vary a mere power. I'll talk about that in a sec. They tried to vary the schedule, but the variation power didn't go as far as allowing you to vary the schedule. And the trustee tried to change the trustee by a deed of variation to get, they got rid of the principal. So the trustee tried to remove the principal without the principal's consent. And this was held to destroy the substratum of the trust. The principal's role is to be a check and balance on the trustee. So removing that role without their consent undermines the whole role of that. I'll just let that sink in while I cough. So trust power, mere power, you could spend a whole hour on this. Trust power is anything that a trustee is under a duty to exercise, whereas a mere power is discretionary. So most of the time, all the things we want to vary is a discretionary power. They don't have a duty to do it. It's just an option for the trustee. McCanty and McCanty, I won't go into that, but these are three more cases that you should read, as well as Jenkins and Ellett. Okay, we're going to have two separate Facebook Lives on re-OEs coming up because it's a really important case. But these are all examples, except for Nariman. McCanty and re-OEs are examples of them having a variation power that did not extend to varying the schedule and notice requirements not followed. So watch the space. There'll be more on that. If you're a lawyer, go read the cases. Really briefly, powers of attorney. So, because we've been talking about all the trust succession, but what about powers of attorney? Are they a good idea? Yes. A few words of warning. Again, you need to make sure that the trust deed contains a power so that control role can delegate their duties. And your actual power of attorney document should specifically refer to the power in the trust deed and make it clear that the donor is granting the power of attorney in their capacity as that control role. So it gets very iffy, like trying to rely on an enduring power of attorney that covers everything for an individual and to then say, well, that extends to their roles as an appointer or a principal. So I really like to make it very specific. You've also got corporations, delegation stuff overlaying all of that, alternate directors, the whole shebang. Do you need to do it for every single matter? I really think it's a timing issue. So my sort of comments on exactly when you need the power of attorney. Firstly, if you've got a good default successor mechanism for an appointer or principal, so someone who doesn't do a lot day to day, then and you've got their attorney or legal personal representative succeeds them on incapacity, then you've probably got that covered. If the trustee level, that's where I think it's most important because they're the day-to-day operator, particularly if you've got like a trading entity going on. So if it just owns shares or something in the trust and it's a bit passive, there's ways you can like sort it out. But if it's a trading entity where you've got creditors, employees, all of that stuff going on, then I think a power of attorney can be really powerful. So a few things. Yeah. If you've got a corporate trustee and not a sole director, usually the other directors can keep continuing. If you've got a sole director and a corporate trustee or an individual trustee and it's a trading trust, this is where it's really helpful. So, okay, that's the end of the technical presentation. Thank you. You've made it. I'm so grateful for all of you who have joined me. I know it's really busy right up to the Easter break. I will just give my trust succession precedents a little plug. So if you're a lawyer, you've been looking at this and you're like, oh man, there's a lot going on. I need to be doing this. Maybe I'm not doing it as to the best possible standard that I could, or you're not totally confident in your precedents, I have released about a month ago a family trust succession precedent pack. So in this pack, you get here we go. A deed of succession template, a deed of variation template, a deed of retirement and appointment, not of trustee, just of appoint or principal guardian. You get cover letters, you get a recommendations letter, and then a letter sending out the draft documents for signing. You've got the 90-minute training video where I do go into all those cases and the lessons, and really detailed user notes. So that's $650 including GST. You get them as Word documents, they're yours. And they're really designed to try to make them, I don't want to say idiot proof, but they have really worked hard to make sure that they accommodate all different types of trustees, that there's a lot of user notes in there to say, watch out if your deed does this or blah, blah, whatever, so that it just makes this process for you faster, more efficient. And the pricing is really, you should be charging like around $500 to $1,000 anyway for preparing these documents. So the idea is that your first one will pay for your first two will pay for the value of investing in this pack. So I'll put the link in the Facebook group. If you go to my website, taraluke.com.au, under the lawyers tab, there's a link there, but I'll also put the link in the group if you want to have a look. I'm mindful that there's not a... Oh, sorry. I'm just having a look at the questions now. I didn't see your question, Damien. Should the principal of a trust have an enduring power of attorney to cover off if they lose capacity? Yeah, great question. It depends on what the deed says. So if the deed says a trigger event is incapacity and that there is a default successor on incapacity that goes to their legal personal representative, then you've already got that covered. You don't need to do a separate one. I probably think, if the deed does not address incapacity, it probably doesn't address death. And I'd be going back to like your fundamentals of saying, well, what are we doing at a higher level for death and incapacity? Which one of these are we relying on? And then do that for all events. I hope that makes sense. And if you do that, then you shouldn't need a special purpose enduring power of attorney. It depends on the deed, obviously. And I just want to say thanks, everyone, for your wonderful feedback. I'm so grateful. And any more questions, let me know. Have a brilliant break. I'm going to wrap this up now. And thanks so much for sticking with me. Bye.